Teaching intellectual property has certain difficulties, especially when intellectual property has to be taught to non-lawyers. Traditionally, intellectual property rights are subjects that are taught in law schools. And again, it is not a subject that is taught in the initial years of study. So it's something, it is a course that will come in the final years of study, in the fourth or in the fifth year. This is largely because of the principles of IP cuts across different subjects. For instance, a law student will know that there are elements of tort law in IP, there are elements of criminal law in IP, there are elements of contract law in IP, constitutional law, international law. So IP, intellectual property rights, a legal student or a law student will know that it is actually a conglomeration of different legal subjects. So that's one of the reasons intellectual property rights is not taught in the first year or in the second year of an LLB course. Now, how does this relate to other branches of law? We have already seen that certain types of intellectual property rights like copyright and trademark can have criminal sanctions. Infringement is made a criminal offense. So that brings in aspects of criminal law. Criminal law is a separate subject in itself. Intellectual property can be licensed, and it is normally licensed through agreements, and agreements are governed by principles of contract law. Intellectual property rights are created under the Constitution. They are subject matters which come under the union list. The central government has power to create it, and some intellectual property rights may have may affect the right of freedom of speech or some of the fundamental rights. So in that sense, there is a bearing on constitutional law as well. Intellectual property right, when there is an infringement is treated as a tort. The remedy of an infringement can be by way of compensation or by way of injunction. So the compensation part is governed by a branch of law called tort. Any civil wrong that is committed can be redressed by compensation. So that brings in elements of tort law. And finally, international law is relevant because almost all the changes that India brought into its IP regime was done by way of the international agreements to which India has been a party. So we have this top-down model that international treaties would set a particular standard which all the members of those international treaties will have to comply with. India is a member, founding member of the World Trade Organization, and because of certain special requirements in the law, India had used a transition period of 10 years to bring its law in compliance with the WTO standards. So today, the Indian Patents Act had undergone 3 amendments in those 10 years to make it in compliance with the WTO obligation. So again, you will find that IP law also is inherently connected with international law. So how does institution, I just brought this out to show you that teaching intellectual property rights as a subject in a law school, which has the competence to do it, itself can be a matter which can put a significant load on the institution and the person who's teaching it. Now, how can we take IP, or how can we ensure that intellectual property can be taught in different institutions which don't even have, say, legal staff or law professors in the faculty? Now, how do we take this forward? So we will look at how IP can be simplified, and that's one way to look at it. There is no need to teach IP with the rigor that is with which it is taught in the law schools. IP can be, intellectual property can be customized, and it can also be simplified to different stakeholders based on their requirements. Now, IP education in the past was largely done by specialist lawyers because before 1990s, intellectual property rights was not even a subject, even in the law schools. In fact, the Bar Council introduced in the late 1990s, it introduced intellectual property right as a subject. So it was not even a subject before that. And that's largely because the creation of the World Intellectual Property Organization happened in the 1960s. So everything that we see with regard to the push of IP into the educational system has happened after the 1970s. Now, there is a need for IP education, and IP education preferably should be something like continuing legal education, because of the nature of IP and the constant changes that happen in the field. It should ideally be something that should be a part of continuous legal education. And the challenges in teaching IP, as I just mentioned, is with regard to the skills and expertise that are available at the ground level, and also with regard to what we should be teaching. An educational institution should be designed to account for the diversified needs in an interdisciplinary manner, by which we mean the focus in institutions, technical institutions like engineering institutions, should be on patents. Similarly, for pharmacy colleges where B Pharm and M Pharm are taught, again the focus could be on patents. For colleges on journalism and media, the focus could be on copyrights. For business schools who have a core course on marketing, the focus could be on trademarks. And for fashion and creative design industries, the focus could be on industrial designs. Now, this is just to say that intellectual property and for agricultural institutions, the focus could be on Plant Varieties Act. Now, the reason I'm just giving this is that IP comes with different complexities, and it may not be entirely necessary for us to cover the entire ambit of IP when we want to teach IP in a non-lawyer setup or in an institution where IP is taught to non-lawyers. Hence, the focus could be based on what is being taught, because engineers largely deal with technology, and IP in technology can only be protected by patents. There could be a small amount of matters which could fall within the realm of copyright, but if you look at almost all the institutions, the technical institutions in our country, and now that intellectual property has become a part of the ranking system, it is also the National Accreditation Council is also looking at the innovation ecosystem of these institutions. You will find that the focus has always been on patents for engineering institutions. So we need to take an approach rather than covering the entire, though this course covers everything, it is meant for a wider audience. When we need to look at teaching IP in non-legal institutions, then we have to adopt an approach of simplifying the IP, one, and two, looking at the IP that is most relevant and to focus a course based on that. So, apart from the law schools, it is the business schools that cover IP in some detail. Now, IP, intellectual property assets, are intangible assets, and intangible assets needs to be managed. And as you had seen how the management scholars look at IP, they look at IP as limited life IP and unlimited life IP, and they constantly try to migrate the value in a limited life IP into a unlimited life IP. So you find, apart from the legal scholarship of IP, the management scholarship also plays a role in making contributions to the subject. So these are the two broad approaches that we have. You can take a legal approach in teaching IP, or you can take a business school approach on managing IP. But the scholarship is largely focused on the legal aspect because intellectual property has evolved as a legal subject. Now, as I mentioned, taking IP to non-lawyers could be a challenge, but it is important because non-lawyers, people who don't have a background in law, are actually the creators and the users of intellectual property. So because intellectual property rights are created and used by people who belong to different segments of the knowledge industry, it is important for us to take this to non-lawyers as well. And as I mentioned, the IP education has to be customized and it has to be simplified. That you have to start with the IP that is more relevant for them, and we'll have to customize it to the industries that we are targeting. If it's technology, then we'll have to focus on patents. If it is creative industry, we'll have to focus on copyright. And if it is marketing and business, we'll have to focus on trademarks. Now, future developments in IP will be interesting to watch. Machine learning and artificial intelligence has itself created certain new issues. Scholars have already started debating on whether products of artificial intelligence, which are largely mission created, should also be granted IP protection. There is nothing that is clear in the law right now, because IP today is confined to products of human creative labor, and that is human creative labor at the first instance, not human creative labor leading to another product by itself. So we are not talking about second generation, third generation products. We are talking about what directly comes from human creative labor. And for this reason, law does not recognize IP even for non-humans. And we had seen the copyright selfie case where a monkey made a selfie, and there was a case in the United States. Law does not extend to it, because law right now defines creativity that is completely attributed to humans. So similarly, mission creativity is also not covered under this. Maybe the first mission that is created, which can make copies or which can duplicate other machines or other which can come up with other creative products, could be the subject matter of IP. But all the derivative products that come out of artificial intelligence, right now the law does not have a provision for this, because creative works have to be directly an outcome of human creative labor. IP will always be important when it comes to international trade. So that's another reason why we should have some amount of IP education, IP in our educational system. And certain sectors like biotechnology and computer science could also have an impact on public health. Now, there is big data that is where our health details could be anonymized, and it could be used to generate very valuable resources. There are privacy issues when it comes to storing and sharing of medical data. And there are also issues with regard to protection of pharmaceutical and biotechnology products, which could have an impact on public health. So for all these reasons, there should be some amount of education on intellectual property rights, and that has to be customized and simplified, looking at the diverse fields of knowledge in which we are currently operating.